Thank you for joining me for today's installment of Disability Chat. Today I'm going to be discussing legal planning in HD healthcare decision making. This is part 2 of a 3-part series. Part 3 will deal with guardianship and conservatorship. As always, information is provided for informational use. This does not substitute as professional legal advice. If you have questions, please speak to me or a licensed attorney in your state. So what I'm going to be talking about today are healthcare decisions, medical power of attorney, and advance directives. All of these things are tied together. You cannot have an advance directive without medical power of attorney, and you cannot have an advance directive or a medical POA without understanding your healthcare decisions. So first, what are healthcare decisions? Healthcare decisions include all decisions about the provision, withholding, or withdrawal of any medical treatment or any course of treatment related to your care. So what does this actually mean? What are your rights when it comes to your healthcare decisions? So you have the right to choose your medical treatment, even if it is different from what your doctor recommends. You have the right to refuse treatment altogether, and you have the right to choose withdrawal of treatment. So this is especially relevant for withdrawal of things like feeding tubes or ventilators. And keep this in mind, we'll discuss this a little bit more later. And then a big part of healthcare decision is competency and informed decision making. These are at the very core of healthcare decisions. So only competent adults have the right to make informed decisions, but they have the right to make decisions about all of their medical care. Informed decisions include the right to know your diagnosis, your prognosis, and the risks and benefit of any treatment. These ideas of competency and informed decision making are really important, and I want you to remember them throughout the entire presentation. We're going to talk more about competency next. So what is competency in general? Competency is having the cognitive abilities to perform a task. And generally speaking, this is directly related to the task at hand, especially when we're talking about healthcare decisions. But a competent individual, generally speaking, is an individual that can communicate choices, that can understand and assess information given to them, and can appreciate the consequences of a decision. So for this, we're talking about like healthcare decision-making capacity. We're not talking about the legal capacity standard, but I will mention that more later. But that's the big legal capacity standard is something that is really important to the HD community and understanding how it impacts everyone, because once you reach the point where you can no longer make decisions for yourself, you no longer have legal capacity, the ability to do all of this goes away. And your decisions will be left up to the legal system, which we will discuss more later. So specifically for healthcare decisions, a competent adult has to understand the nature, extent, or consequences of the proposed treatment. They can make rational evaluations of the burdens and risks of treatment, and they're able to communicate a written decision. And this is pretty broad, but they're able to write, they can indicate yes or no, they can sign an X. You don't have to be able to sign your name or things like that to be able to communicate a decision. So to sum up, this is a 4-step guide to healthcare decisions. This is a very oversimplified guide, but it will help you start the process. So 1, review your healthcare information. 2, review your wishes and needs. And this is beyond just healthcare, like what are your wishes and needs for life? Then set your expectations based on your healthcare information and what your personal wishes and needs are. How do your decisions go together? And then create a plan that reflects the present and the future. Really, I should have put a step 5 bullet point. Step 5 is tell the relevant people in your life. None of your wishes and needs can be met if the relevant people don't know about it. Which brings us to medical power of attorney. So what is a medical power of attorney? It is a legal document that grants a specific person the ability to make and enforce healthcare decisions on your behalf when you are unable. And really, this is more talking about like unable in a medical sense, but it can also mean unable in a whole legal capacity sense, covering all your bases. So there are 2 main kinds of medical power of attorney. There's a general medical power of attorney. This expires when a person is deemed legally incapacitated as defined by state law. And then there's a durable medical power of attorney. This stays in effect even when a person becomes legally incapacitated. And this is necessary for individuals impacted by Huntington's disease because, generally speaking, at some point in the disease progression, a person with HD will meet the definition of legally incapacitated. And if you do not have a durable power of attorney, once that person meets the definition of legally incapacitated, you don't want your document to expire. You do not want to have to go get guardianship and conservatorship. It's incredibly expensive. It's very time consuming. You have to go to state court. When it comes to power of attorneys for HD, they need to be durable, whether it's a legal power of attorney or a medical power of attorney. You always want to make sure it is a durable document. And really, what that means, the big difference is in a durable power of attorney or a durable medical power of attorney, there will be language that says this power of attorney will remain in effect even if this person is deemed incapacitated. You need to have that extra language to make sure you're protected, the person you may be power of attorney over is protected, to make sure everybody in the situation is protected. It needs to be a durable medical power of attorney. So when does a medical POA take effect? When do you become medically incapacitated? So instances are when you're under general anesthesia, you have an illness that leaves you unable to communicate, or you're in an unconscious state. Like this, you could be in an emergency situation and you got in an accident. But these are all things that you can come out of. When do you become medically and legally incapacitated? In this instance, we're specifically talking about a degenerative disease that impacts your ability to make a rational decision. But the standard for legal incapacity is really high. So you could be medically incapacitated for a while, or you could be in the gray area where you can kind of make decisions for yourself, but they're all bad. But it doesn't rise to the level of legally incapacitated. And part of the reason I'm talking about all of this today is you want people to know what your wishes are. You want to have good people in your corner who will fight for you, who will make sure your wishes and rights are honored, and will make sure things that you're taken care of, even if you're still at the point where you can make your own decisions, but they're not necessarily great decisions. So what can a medical POA do? They can do a lot. They can decide what medical care you receive, including surgery, medical treatments, medication, and home health care. They decide what medical care, where you receive medical care, what providers and doctors oversee your medical care. They decide where you live, including assisted living, nursing homes, or residential long-term care. And they decide who provides your everyday care needs. So you want to make sure you trust this person, and you really want to make sure they understand what your wishes are. It's a lot easier on both of you if you know what your wishes are and you communicate them to the person who may one day have to enforce those wishes. So all of this ties into an advance directive. And an advance directive are legal documents that provide instructions for medical care when a person can no longer communicate their own wishes. These documents only take effect once a person is unable to communicate their wishes. So there's two parts to an advance directive, the medical power of attorney, which we just discussed. And again, the person you appoint should be familiar with your values and wishes and who can make healthcare decisions for you. And then the next part is the living will portion. This tells doctors how you want to be treated, what medical care or treatments you want to avoid, and when your choices apply. So who needs an advance directive? Everyone. Everyone. Because no one knows what could happen tomorrow. We could get hit by a bus. Like, you don't know what's going to happen. And planning for the future now means you help ensure you get the care you need and you appoint someone you trust to make important healthcare decisions. Not a lot of people assume that doing this paperwork means they're giving things away. No, it means protecting what you want. If you are get in a coma tomorrow and you've never had this conversation, no one has any idea what you want, and they cannot enforce it. They have to make their best guess, and their best guess could be the complete opposite of what you actually want. Putting things down on paper is the only way to make sure your wishes are honored. And the benefit of doing this with HD is Advanced care planning can give you a sense of control over an uncertain future and allow you to participate directly in the decision-making process. And I know it's really hard for me to sit here and just say that. Um, no, I am not personally impacted by HD in my family, but I work with it every day, and I don't take these things lightly. I don't want to just make these statements to people because I know they have a really severe impact. I am making this presentation, I provide this assistance because I want everyone in the HD community to be able to participate directly in their decision-making process, to have their wishes outlined and met, and to have the care team around them that they need. And while this is so hard, it is really important to do this as soon as possible. The reality of this is hard, but once you lose the ability to make decisions with HD, you do not get it back. This is not an all or nothing process. Many people start struggling to make good decisions for themselves long before they lose the ability to make decisions altogether. And one of the really unfortunate things about our legal system is you are well within your rights to make terrible decisions for yourself as long as you understand that you are making terrible decisions. If you are not an immediate danger to yourself or others, no one is going to make you get care or make you make decisions that are better for yourself. And unfortunately, that often means people die passively because they are not a burden on the system. They are just sitting quietly at home, not getting medical care, just minding their own business, and the legal system isn't going to force them to take action. But having a support system around you, having an advance directive, a living will, having things written out on paper that people can go to your doctors or to you and be like, hey, this is what you said. This is what you want. Let's get this done. That can be really, really powerful. So, what happens if you are unable to make medical decisions and you do not have an advance directive or a medical power of attorney? State laws will determine who can make decisions, and usually there's a hierarchy. It'll start with a spouse, then it'll go on to family, close friend, and finally, if there's no one else, a designated paid professional. And the reality is, these rules only really take effect if you are hospitalized or in a facility. This is an example of where the way the law is written and the way it is actually enforced is very different. As I said previously, if you are not a danger to yourself or others, the legal system doesn't really care if you get medical care or not. If you are not bothering anyone, if you're minding your own business, you're just sitting in your own home, the legal system is not going to make you get something you don't want to get. So, how do you go about creating a medical power of attorney and an advance directive? You start by appointing an agent. So, your healthcare agent is your trusted friend, family member, loved one who will make medical decisions for you when you are unable or enforce the decisions that you have outlined. So, your healthcare agent will have a lot of authority. Make sure to pick someone you trust and has your best interests at heart. Create a list of backup agents because there could be things in their lives that make them unable to do it for you anymore. And definitely rank them in order of priority. And make sure you speak to potential agents beforehand because this is something that they need to agree to as well. Like you don't want to put all this paperwork into place, you get everything done, and then the person you want to be your agent is like, I don't want to do this. I don't want to have anything to do with this. Talk to them first. And it's important to have conversations with them as you're filling out all this paperwork so they know what's going on and they know what decisions to help enforce for you. So here is an example of what an advance directive looks like. I thought it would be really helpful to look over this because that's part of the scary part of this process, having no idea what to do or how to fill out the paperwork. This is pretty straightforward. This example is from Tennessee, but here it says, you fill in your name, and then it has spaces for multiple different agents. And then if you look at the bottom, and we'll talk about this a little more, this specifically says when it's effective. And we'll talk about that a little bit more in a few slides, but all of the examples I'm going to show you, there's spaces for alternate agents because it's really, really important to have a backup. This is an example from Virginia. They have a space for 4 agents, and you can have the option to list additional agents on a separate page. So having backups is clearly really important in this process. So once you've decided who your agents are going to be, then you need to decide when the document becomes effective. So when will your agent have the authority to act on your behalf? Are you going to give blanket authority? Will there only be specific instances when they can act? Or can they only act once you're incapacitated, meaning you can't make decisions at that time? Here are two different examples of what the effectiveness paragraphs can look like. One is just a checkbox. The first, I give my agent permission to make healthcare decisions for me at any time, even if I have capacity. That's a blanket statement. Or I do not give such permission. This form only applies when I no longer have capacity. And then the last one is just a general paragraph um, stating I grant my agent the full power and authority to make healthcare decisions if I am incapable. And if any physician examines me and decides that I have the ability to make my own decisions, all further healthcare decisions will require my informed consent. So there's multiple ways you can have that written out. The next thing is then you need to decide which healthcare decisions you want your agent to make. Again, this can be general or specific. Here's an example of a general statement. In making healthcare decisions for me, my agent shall follow my wishes and preferences as stated here or otherwise known. If my agent cannot determine what healthcare choice I would make for myself, then and only then he or she must make the choice based on what he or she believes to be in my best interest. This language clearly indicates that the person whose living will this is thought out what decisions they want made. Like the whole purpose of this is when you're giving someone power, you're not giving them unlimited power to make decisions over you. Really, what it is you're giving them power to enforce the decisions that you should have already stipulated and told them explicitly when you were together. You're not giving something up, you're empowering somebody to enforce the choices you've already made. That's a very important distinction. So here's an example of very clearly laying out what powers your agent has. And I'm not going to read through all of these, but you can see it's very descriptive and detailed. Another way to do it is indicating your wishes for quality of life. So how do you want to be cared for based on these different conditions? Indicating your wishes for treatment. So what kind of treatment do you want if you are in these states? So once you have indicated how your power of attorney, oh my gosh, how your medical power of attorney can act and what things they can make decisions on your behalf or what decisions you've already indicated you want made, then you need to complete and sign the form in accordance with the laws of your state. Some states require witnesses. Some states require the document to be notarized. Some states require both. It's important to understand what your states require. It should be on the document. But here is an example of signatures with witnesses. And then this one, they can either accept witnesses or you can have it notarized. Either or. Those are very, very common. So once you've correctly filled out all the paperwork, the next big thing is giving a copy of your advance directive to all relevant parties. Your document doesn't mean anything if it doesn't get into the hands of the appropriate people, which include your agent and your physician or your HD clinic. And you want to make sure you update your advance directive or your medical power of attorney as your circumstances change. So does your agent list need to be updated? Were you married and you have since gotten divorced? Did somebody on your list pass away? Or have your medical care wants and needs changed? Because that's very possible too. Like if you're doing everything now, things could definitely change between now and possibly losing incapacity or just now and 10 years from now. Life is always changing. So that means your wants and needs may also change. So do not be afraid to change your advance directive and your medical POA. And that means you have to review it every once in a while so you know what it actually says. addition to advanced directives, there are other advanced planning forms like do not resuscitate or a DNR. This becomes part of your medical chart and informs medical staff that you do not want CPR or other life-saving measures. There's a do not intubate, which informs medical staff that you do not want to be on a ventilator. There's do not hospitalize. This informs long-term care providers that you do not want to be sent to the hospital for treatment at end of life. And these are kinds of things that may get added later or things that change. This is just an always ongoing process. It's much better to have a baseline and to have everything put on paper first. But these are just things to consider. Not saying you have to do all of this today, but it's very important to recognize what these forms do and do not do for you. And if you don't have these, then your wishes can't be honored. If you don't want to be resuscitated, but you never complete a DNR, the medical providers, your loved ones, they won't know that. They can't enforce that. And then the last thing I want to talk about, which is really important, is cost. So durable power of attorney, the average cost is $200 to $500, depending on the complexity. You can definitely create a free power of attorney with minimal notary costs. You want to make sure it is durable and that it complies with state law. So that's durable power of attorney or durable medical power of attorney. Advanced directive, similar cost, again, depending on complexity, and there are also many free resources to help guide you through this process. Really, the point of this is to highlight the extreme cost difference between getting a power of attorney and an advanced directive over guardianship and conservatorship. Power of attorneys maybe cost a few $100s. Guardianship and conservatorship cost thousands upon thousands of dollars and are very, very time consuming. It shouldn't take a lot of time to get a durable power of attorney completed. It could take months to fight for guardianship and conservatorship, and you'll likely have to incur additional costs for medical testing and reports. You will actively be fighting with the loved one you're trying to get guardianship and conservatorship over most of the time. It's not always, but usually in situations I have seen, guardianship and conservatorship is being sought because the person who can't make decisions for themselves and is not taking care of themselves doesn't want to take care of themselves. They don't have the capacity. They are fighting everything, which makes the court battle that much harder. And that's not true of everyone, but the cost is true. Like, it is very expensive. Do the daggone power of attorney and advance directive to save yourself time, money, hassle, everything. It's not fun to do it, but it is a weight lifted off of your shoulders because it means everything is on paper. Everything is said and done. And it is a fight you do not have to have later. This is not something worth putting off. And finally, what are some good resources? A resource that I really like is Prepare for Your Care. It's literally just prepareforyourcare.org. It walks you through making a personalized advance directive. It asks you questions. It helps walk you through the process. Another great resource is the National Academy of Elder Law Attorneys. They can help you find an attorney to walk you through this process along with estate planning. So that's a great option if you haven't done anything. Estate planning is really important. That was part one of this series. And finally, a Google search. A Google search can be really great if you type in your state plus advanced directive, but only use sources that are from the government, the state bar, or legal aid websites, because those are trustworthy sources. And those usually mean that they are official documents from the state. If it says this is approved by the state of Tennessee, this is Virginia official, that means it complies with state law. But you need to make sure that the website ends in .gov or .org. Otherwise, it's not necessarily a trustworthy source. And again, you don't want to go through all of this, get everything complete, and then it doesn't actually comply with state law. That would be devastating. Let's not do that. If you have questions, this is how you can find me. I really hope this was helpful. I hope this makes this process a little less intimidating. There are a lot of really, really great resources out there. You do not have to do this alone. You're not creating a legal document from scratch. But it's important to get all of this done. It's important for everyone to do it, whether you have HD or not. It's just, this is an important thing that everybody should plan for, because as much as we would all like to, we are not going to live forever. I hope this was helpful, and please contact me if you have any questions.